I now recognize the chairman of the subcommittee of on the Constitution, Civil Rights, and Civil Liberties, the gentleman from Tennessee, Mr. Cohen, for his opening statement.
Thank you, Mr. Chairman. As chairman of the subcommittee, which has a distinguished list of former chairman and ranking members, I'm proud to be that member, and we have a great committee. We've had extensive hearings, as has the committee, and outstanding witnesses. And it's been clear, including testimony from a professor from Caltech who studied the statistics of all of this, that we need a pre-clearance formula, that it helps people vote, that the voting impediments were in the states, mostly, which were struck down by the Supreme Court, the old Dixie states, that had an opportunity to come forward, but instead, old times there were not forgotten, and they continue to find ways to disenfranchise people. So we have done our job. The H.R. 4, the Voting Rights Advancement Act of 2019, would once again give effect to the pre-clearance requirement of Section 5 of the Voting Rights Act, gutted by Shelby County versus Holder, as the chairman has mentioned. That struck down that coverage formula that was necessary. As a result, pre-clearance provision remains dormant until we adopt a new one, and we hope to do this session. I want to commend Mr. Sensenbrenner, who was a chairman at the time, who helped pass the Voting Rights Act in the early part of this century, and was one of the supporters of renewal in a previous Congress. He's been a stalwart on this, and I thank him for his work. H.R. 4 was introduced by Terry Sewell of Alabama, an outstanding congressperson, and her district includes the Pettus Bridge, where John Lewis marched and was beaten by Alabama state troopers to get people in Alabama the right to vote. People have been brutally beaten, some have been killed, to stop people from getting the right to vote. That's sad in America. It's happened in Alabama, it's happened in Mississippi, it's happened mostly in southern states, which is unfortunate that it happens anywhere. But we need this new coverage formula that would be one that would say if you had 15 or more voting rights violations that occurred in that jurisdiction over the previous 25 years, or where 10 or more violations occurred, if at least one of those violations was committed by the state itself, then you'd have a area that would be covered by pre-clearance. If the political subdivision would be covered also if it had 3 or more violations in the previous 25 years. Jurisdiction could be covered for a maximum of 25 years. Some have said, for a maximum of 10 years, excuse me. Some have said that you shouldn't have these standards and have to go to court to get your laws enforced and have a pre-clearance. That is wrong. But we do have in our country, and as we should, laws about people who commit wife abuse, and they have certain restrictions put on them before they can take certain actions. They have injunctions to protect the public and protect the individual who's a victim of the abuse, sexual assault. Doesn't have to be wife abuse, it's sexual assault. And we have it in other areas. And with these states have had certain number of violations in the previous years, they are basically just like an abuser, a sexual abuser. And if you have knowledge that they are, you're foolish not to put some restrictions on them to protect the person that's been abused. In this situation, we're protecting the people who live in the jurisdictions that have been abused in the past because they've shown their colors. And as Maya Angelou told us, when they show you what they are, believe them, because you see what they are. And that's what this is about, pre-clearance. When people have shown you, political jurisdictions, what they're about and what they think and how they act, you must put up some pre-clearance requirements. Otherwise, it makes no difference because they can do their, as was said in Blazing Saddles, that their voodoo that they do so well, they can do that and they get away with it because you can't stop it before the election's been held and you've stopped people from voting. So this strengthens the Voting Rights Act in other ways as well, includes enhancing the Act's bail-in pre-clearance provision, adding a new practice-based coverage formula, and revising the preliminary injunction standard for enforcement actions under the Act, so plaintiffs can more easily halt potentially discriminatory voting practices while they're being challenged in court. The right to vote is the most fundamental right in our democracy. It's the key, it's which we rest upon, the fulcrum. Unfortunately, the right of African Americans and other members of racial and language minorities to vote has been threatened and undermined throughout our nation's history. It's a sad part of our nation's history, but it's always been there. Count the number of peas in a jar. Multiply 16 times 14,667. And if you can't pass those tests, you don't vote in Alabama. That was the law before some of these, the 50s and 60s and before. They gave the African Americans the test. They didn't give the Caucasians the test. They got a waiver. Voting Rights Act with an effective pre-clearance provision went a long way towards righting those wrongs we've seen in our nation's history, but sadly, since the effective neutering of pre-clearance provisions, voting rights for minorities once again under assault in many parts of our country. We gathered evidence in our subcommittee, with 7 hearings before the subcommittee. We had 1 hearing before the full committee and multiple hearings in other committees. That evidence provides an extensive and detailed record of continued and ongoing voter suppression efforts, particularly by those jurisdictions that were once subject to pre-clearance in the effective absence of pre-clearance since the Shelby County decision. North Carolina jumped into action with a sweeping voter suppression law that a federal appeals court, right after Shelby County versus Holder, they passed the law and the federal appeals court held it unconstitutional, finding that it intentionally, quote, targeted African Americans with almost surgical precision. We also heard about recent measures to make it difficult or possible for minority voters to exercise their right to vote. Those measures include polling place closures and relocations, the purging of voter rolls that disproportionately target racial and ethnic minority voters, discriminatory photo ID laws, and restrictions on ex-felon voting laws, all of which are designed to make it harder for African Americans and other racial and ethnic minorities to vote. I would submit that disparate impact is important, and it shows the intent of the parties. And it's been shown to be the intent of the parties in many parts of the country, but particularly in the Deep South. Last month in Memphis, we learned about Tennessee's third-party registration law that would impose draconian penalties on groups like the League of Women Voters, who work to register new voters because of minor errors and omissions in registration forms. They would face criminal penalties, a way to try to get them not to engage in voter registration and restrict their activities. Federal court temporarily blocked this, finding that it was troublingly vague. Back in May, we learned about a similar law in Texas, about many other examples of voter discrimination in Texas, which has proved to be particularly troublesome recidivists when it comes to voter discrimination. They jumped into action just like North Carolina and passed a law as soon as Shelby County versus Holder came down. So we've seen states engage in racial gerrymandering designed to dilute the strength of minority voters. We've seen that in many areas, particularly North Carolina and others. The Voting Rights Act pre-clearance provision required certain jurisdictions with a history of voting discrimination against racial and language minorities, again, those predominantly in the Deep South, to obtain approval of any changes to voting laws and procedures from the Department of Justice, the U.S. District Court for the District of Columbia before such changes take effect. My friend, the ranking member, says that the Justice Department can't be so trusted. They get involved in these things. Well, I don't think you have to worry about that with this Justice Department. But if you get another Justice Department, you have to worry about it. To quote my friend Mick Mulvaney, get over it. Things happen. This mechanism ensured that new voting rules and practices in jurisdictions with a history of discrimination were fair to all voters. It rightly prevented potentially discriminatory voting practices from taking effect before they could harm minority voters. And in this way, pre-clearance proved to be a significant means of protection for the rights of minority voters. Congress has repeatedly reauthorized pre-clearance provision on an overwhelmingly bipartisan basis. Most recently in 2006, when Sensenbrenner was chairman of this committee, and the House passed it 390 to 33, and the Senate 98 to nothing. A result due in no small part to the substantial efforts of Mr. Sensenbrenner and then subcommittee ranking member Nadler. In the absence of an effective pre-clearance regime, it is unsurprising that discriminatory measures have and will continue to undermine the voting rights of racial and language minority voters and erode our democracy. While Section 2 of the VRA, which prohibits discrimination voting, remains in effect, it is much less effective, significantly more cumbersome, and often prohibitively expensive to enforce the act. Most importantly, plaintiffs cannot invoke Section 2 until after an alleged harm has taken place, after the horse has left the barn. Elections taken place. People have been stopped from voting because of these laws. And so you can say later, oh, it was illegal, but the election's over and the folks are in who wouldn't have otherwise been in. Requiring discrimination victims to rely solely on such a remedy, Section 2 neuters the act. The onus, therefore, is on Congress to create a new coverage formula to restore the Act's most important enforcement mechanism. It's a pre-clearance requirement to find other ways to strengthen the Act. H.R. 4 goes a long way toward meeting this obligation. So, in the spirit of all the civil rights workers who worked hard to get people the right to vote, particularly with honor to John Lewis, who was beaten in Selma, Alabama, and others who were beaten, and people who were shot, like Miss Leozo from Detroit down in Alabama, and Schwerner, Cheney, and Goodman, who were killed in Mississippi, in Philadelphia, Mississippi, when they went down there to register people to vote, Freedom Summer. In respect of their sacrifices and fairness and justice, we need to pass H.R. 4 and urge the committee to report it favorably to the full House. There's no problem with disparate impact. There are problems today in getting people to vote. They are clear on the face of history and the current course of events and legislation in our nation, particularly in the Deep South. With that, I yield back the balance of my time.